Next case is State versus Acres. Each party will have 15 minutes to present their argument. Counsel, how long would you like to reserve for rebuttal?
If I may, 3 minutes, please.
3 minutes?
Yes, please, thank you.
Sure. I'll be keeping time up here. I will try to let you know when you get to about a minute left, so you know if your time is wrapping up. And I'll do the same for you, counsel, at the end of your time when you're about a minute left as well. When you come to the podium, number one, please come up. Please stay behind the podium as we're video recording or also audio recording, so please speak loud. Introduce yourself when you come to the podium. I don't think in this case there's any minors or anyone that we're going to use victims, but if there were, please use names, initials, or something like that rather than the name, full name of those folks. We read your brief and are ready to proceed whenever you are. Thank you.
Good morning, Your Honors. Attorney Catherine Meehan on behalf of Logan Acres. So today we're here essentially challenging the trial court's denial of a pretrial motion to suppress. There were several different issues that were raised at that hearing and determinations regarding the admissibility of evidence. Specifically, the first thing I want to talk about is the court's finding that this was a community caretaking function which essentially permitted the balance of the interaction with Mr. Acres to occur. Part of the reason why we take issue with the community caretaking function specifically is how this vehicle was on the side of the road. So we have a 2-lane road of travel. We have a vehicle that's parked over the fog line onto a paved shoulder, not in the grass, not displaying any signs of distress. And the officer, I believe, was actually traveling in the opposite direction, turns around, positions her cruiser behind him, puts her lights on and approaches the vehicle.
Counsel, I'm not sure how dispositive this is, but every time I was reading the somebody saying that he was on the side of the road and he was lawfully parked, you can't lawfully park along the side of the road, can you?
So I don't believe on this road there are any specific restrictions on parking. There may be some sort of time limitation on when you can park. Sometimes it's after 2 a.m. You're not permitted to park on the side of a road. We're not dealing with a yellow line, we're dealing with a white fog line, so I do believe the statute does permit at least temporary parking in that location. And I appreciate the question because that'll segue into my argument on the case law that specifically talks about whether or not the community caretaking function is permissible when a car is lawfully parked. And the examples that are within those cases, the case that I cited was the Clapper case. That case is a little bit different. That was actually a rest stop where the person was parked in a parking space. But all of the cases that were cited within that case that determined where a vehicle is not where it should be parked essentially were quite different circumstances. One of the cases was a driver obviously sleeping in a bank drive-through parking space or a drive-through. Somebody sleeping in that bank lane. Another case cited within the Clapper case was somebody who was stopped partially in the roadway on a 2-lane road. And then another case within that Clapper case was somebody who was actually stopped in the middle of the road. So not locations that we would ordinarily expect someone to be stopped. And so this case I believe is different because we do have, again, white fog lane, paved shoulder, vehicle parked, and some of the testimony that was presented at the hearing was that there was nothing unusual about how it was parked. And so we have a vehicle that's straight, not parked slanted, not crooked, not into the grass. There was nothing about the vehicle itself that demonstrated that there was any sort of need for assistance.
Did the vehicle have the hazard lights on?
The hazard lights, yes, were illuminated.
Wouldn't that be a sign of distress?
So, could it be a sign of distress? I'm sure it could. I think in the context here, it's more of a warning to other vehicles on the road so that they don't strike that vehicle. I think that's more of the purpose of the hazard lights under the circumstances. But when we were presented with the testimony at the hearing, there was no testimony from our officer where she actually presented any sort of reason as to why she thinks he needed assistance in order to protect life or prevent serious injury, which is what the case law allows in the community caretaking function. So, and those were the questions that were posed at the hearing. Was there any evidence of damage to the vehicle? There wasn't. So there was no signs that there was an accident or collision. No damage to the front of the vehicle, no damage to the back of the vehicle. There weren't any flat tires. the driver wasn't out of the vehicle, the hood wasn't up, the vehicle wasn't smoking. So no outward signs of distress, simply a person stopped on the side of the road. And again, in this circumstance, when the officer approached, she quickly learned the reason that he was stopped on the side of the road was that he just took a phone call, had learned that his grandfather had passed away. So reasonable, again, essentially reasonable reasons for him to be stopped in that location. I did cite within my brief additional arguments why I think that even if the court does find this is a community caretaking function, which would have necessitated a stop, that it went beyond the scope of that investigation, and then it turned into a further criminal investigation. And so that's what we take issue with, the timing of everything. She, again, positions the patrol car behind him, puts her lights on. That's a show of authority that means that this is not a consensual encounter. Even when she approaches the vehicle, the initial question is everything okay? That's where she immediately
Well,
learns.
just like he had his hazards on to warn other cars he was there, wouldn't her turning her lights on also warn cars that were there to make sure it's a dark unlit area that there's a car on the side of the road, they should be careful?
So, other passing vehicles?
Yeah.
Sure. But from a subjective perspective of the person that is in the vehicle in front of the police car, when the cops stop behind you with their lights on, that's an exhibition of authority. And I think that is actually, I think we can infer that from how the conversation goes when she starts speaking with Mr. Akers. This was one of the things that the court put in its judgment entry where he had offered his license. Because again, from that perspective, there's a cop behind him, the lights are on, she's at the side of his door, she's asking him questions. He feels obligated to provide his license.
What question does she start asking him?
So the first question she asked him is if he was okay. She said, "You seem off." That's where she learns that he stopped on the side of the road to make a phone or take a phone call, and then it's after that she asks him for his license.
When she's asking, are you okay? Doesn't that make it sound like it's a community caretaking function, that she's concerned about a person on the side of the road with their hazards on late in the evening?
So sure, and I said that the inquiry there is finding out why the vehicle is actually stopped in that location. And then the argument that we're raising here is that immediately that's dispelled and disposed of. We know that there is no immediate need, there's nothing significant about him being in danger or any sort of risk to him because he's parked making a phone call essentially. So those were the arguments raised just regarding the community caretaking function, and then obviously it turns into an investigative stop, and then we go through the field sobriety tests, and he's ultimately arrested. The second assignment of error, and I think this is one of the more important things regarding this case on appeal, is the denial of the suppression as it regards the admissibility of this breath test. So at the hearing, it came out, so the test in this case, there was a positive test on this machine. The certification on this specific breath testing machine was last certified in December of 2022. The test in this case is obviously the next summer, but it wasn't recertified. This machine wasn't recertified until after that test. At the time of the certification, Mr. Whitmer from Ohio Department of Health, he didn't actually properly certify the machine under the regulations that were in effect at the time. The thing that we compare it to, because I haven't found much case law regarding this specific issue, I think it's one of first impression as it comes down to, is a test on a machine admissible if the machine itself wasn't properly certified at the time of the test.
This state in its brief, and you did not reply to this, argued that this is covered by state for Tucholsky, which is our case, which said when you plead to OVI and BAC, the BAC is merged in the OVI, then it's moot in essence, because you weren't sentenced on the BAC, just the OVI. So any BAC problem is moot. How would you respond to that?
So my response to that, and I appreciate that question, is respectfully, I think the court got it wrong. And I'll tell you the reason I think that is because when then would a person that challenged a breath test in a pretrial motion to suppress that was denied ever have the opportunity to challenge the court's ruling on appeal? Let's say this person decided not to plead no contest and went to trial. So we lost the motion to suppress, we go to trial, and jury finds you guilty of all counts. At sentencing, they merge they merge the OVIs again, and then we have your direct appeal. Now so when would that person ever have an opportunity to challenge the court's determination?
Why would it matter? How is he prejudiced or how is she prejudiced? Even
So-
under your scenario, how are they prejudiced? Because you just said it's merged.
Well, I was saying, just in the Cherkasky case, they merged them, so I'm suggesting if that were to happen, and you were sentenced and the sentences were merged, how could you ever challenge the court's
Right,
ruling? You couldn't.
and my point is, why does it matter? Because you're not prejudiced, are you? Because the whole point is, it's a merger and you're sentenced on the failure to, on the DUI.
So I think the issues would come down to, I guess it depends. So a breath test, like for instance in this case, and I'm sure you guys have watched the video, this is not a case where you watch it and you say this person is absolutely impaired, he does not look impaired. But for that breath test, I think if the breath test comes in, it's absolutely easy to prove the OVI because of the prohibited breath test amount. If you're going solely on the impairment, I think it's a harder case, which is why the prejudice to my client in this matter would be if that breath test comes in and we don't have the ability to challenge it, then we're going to trial on a case where we just have this number associated with it. Does that make sense?
So you're saying the point is, it's not a matter of the sentencing, it's a matter of it affects the ability to
Correct.
try your case.
Correct.
And affects the perspective for the jury.
Absolutely, because if the court were to say that this breath test was inappropriate and shouldn't be admissible, then that makes it obviously a more triable case from the defense perspective as it relates to the A1A specifically.
When you have an issue, I'm just curious over this too, and it might be obviously just negotiations, but, and maybe the prosecution won't cooperate with this, but if you're contesting the breathalyzer, why wouldn't you just plead to the BAC instead of driving under the influence?
So-
You have about a minute left on the meeting to
That's okay.
Carl.
No, sure. So in cases like this where the intent is to file an appeal challenging the court's ruling, it is almost always we have to plead as charged, and it's no contest to preserve the appellate right.
But wasn't he charged with both?
He was, absolutely.
I'm sorry.
Isn't this an underage OBI?
It is, yes.
And he admitted to drinking?
Initially, he denied drinking, later he admits to drinking.
Okay.
But back to the BAC argument specifically, so the regulations that were in effect at the time essentially said that the machine, if it didn't test within that .005, the machine was required to be removed from service until it was serviced or repaired. Mr. Whitmer testified that that did not occur. It would usually get shipped out to, I think, Kentucky for services or repairs. So that didn't actually occur. And again, the case that I think is comparable is the Burnside case. That was one specific to a blood test, but essentially the statute said you shall draw the blood with the anticoagulant, and it didn't. The court found that that term shall essentially demanded an action, and I think that the statute here that says will require the instrument to be removed from service also demands an action. So we can't have substantial compliance if the thing that the statute says has to occur doesn't occur. And so we think that the court erred in that regard.
And you're in a rebuttal time now, Counsel.
Thank you.
May it please the court, my name is Greg Huber. I represent the state of Ohio, the appellee in this case. We respectfully disagree with the assertion that this appellant's vehicle is lawfully parked along Ledge Road. Respectfully assert that this case is different than this court's previous holding in the Clapper appeal. I tried the Clapper case, I handled the appeal, I know Trooper Sanko was involved in that. In that case, Ms. Clapper was parked in a rest area and was not parked in an unusual manner. The only notice of something wrong was that she tapped her brake lights several times, which caught Trooper Sanko's attention. He wondered what was going on, and he walked over, and when she rolled down the window, he thought he had walked into a distillery, and that initiated a sequence of events that resulted in the Clapper case. This court felt that because she is in a rest area, is lawfully parked, and tapping the brakes didn't seem to be particularly alarming, that the community caretaking situation didn't properly apply. I was not particularly happy with the decision, but that happens, and I can understand the rationale. I think this case is different. The gentleman here is on Ledge Road on a Saturday night leaving Sunday. It's 1 o'clock in the morning. It's very dark, not well lit. Sergeant Parente had driven past this area where the gentleman's pickup truck ultimately was stopped, and there was nobody there. She comes back a second time because she is on patrol in this area, and she sees this vehicle pulled off the side of the road. Ledge Road is a fairly heavily traveled road. It's not well lit, and the gentleman's hazard lights were continuously on, which prompted her to go down past him, turn around, and then come back. She testified she thought maybe something was wrong. And frankly, in my experience, most police officers on a road like Ledge Road, where there's a vehicle pulled off the side of the road, even though it's off the fog line, the hazard lights are on. A reasonable officer, if you look at the situation through that person's eyes, would likely stop to see if anything is wrong, because there could be any number of things possibly wrong. This vehicle was not there before. It's not a parking area. To say that it's lawfully parked, in my opinion, respectfully, is a stretch. I don't think it is lawfully parked.
Was there, and I know the person wasn't charged with anything, but did the officer testify that this was an area that was unlawful to park? Is that in the record before us?
She states that he's off the side of the road and does not offer any opinion that it's a parking area. So the way she describes Ledge Road, I think it's reasonable to conclude it's not a parking area. It's just the side of a rather heavily traveled roadway. I think the facts in this case are similar to what this court ruled upon in the case called State v. Korn that I cited in my brief. State v. Korn was a situation that I also tried. The trooper, Sergeant Nemisto, came upon a vehicle pulled off I-71 with its stop outside the fog line, but its right turn signal was on. It was stopped. He thought something was not right because it stopped there on a fairly heavily traveled roadway, although at the time the traffic was rather light. He pulled behind the vehicle to check to see if the gentleman was all right, and immediately was confronted again with a person who had an extremely strong odor of alcohol, which then led to the questions that result in investigating a possible OBI offense, which leads to getting the gentleman out of the car. That same scenario applies in this case. The first 2 minutes that the court looks at the body camera footage from Sergeant Parente reveal most of what took place, and it happened in a continuous sequence. Sergeant Parente pulled up to the gentleman's, or walked up to the gentleman's driver's side door and asked if everything is okay. She immediately takes her flashlight and looks behind the back of the pickup truck, and you can see in the video that she does so, and most officers that I have interaction with will check immediately the surrounding area to see if there's any other person in the vehicle or see if there's any weapon, which is what happens in this case. In doing so, she immediately noticed an open White Claw can behind the defendant, and she asked the gentleman again, "Are you okay? How old are you?" He immediately states he's 18 years old, and she states verbatim, "Is everything okay with you? You seem a little off." And he then states that he received a phone call with respect to the news that his grandfather had passed away, and she asks him, "Are you intoxicated or something? Are you all right?" And he states that she asks him if he's been drinking. He says no, and then she immediately confronts him and tells him, "You smell like an odor of alcohol, and you have an open container of White Claw behind you. Have you been drinking?" At that point, he states that he had 1 or 2 White Claws 3 or 4 hours previously, and they had been at a graduation party. And the event this occurs is June 4th, which is probably about the time where a graduation party might occur. She made observations that she testified about, which involved the fact that his eyes were exceptionally glassy and he seemed somewhat slow, seemed to be somewhat off. The fact that this gentleman is 18 years old and has an open container of an alcoholic beverage in the vehicle and is admitting that he drank is pretty powerful information for a police officer who is on patrol. And in this case, it was, in my opinion, sufficient in light of the other observations for her to ask him to get out of the car so that she could test to see whether he was impaired. In this case, she asked this gentleman to step back to a patrol car. She seats him on the bumper of her patrol vehicle. She performs a horizontal gaze and nystagmus test. Trial court found that she did not administer the test correctly, but also notes that she did find and testify to seeing nystagmus in this gentleman's eyes. The appellant challenged the administration of the walk and turn test, arguing that this gentleman apparently had gotten in a physical confrontation at the party and that may have rendered the walk and turn test suspect. I would respectfully ask the court to look at the first 3 minutes of the body camera, because she does a pretty thorough job of asking this gentleman, are you okay? Do you have any head injury? Do you have any injuries that would prevent you from completing field sobriety tests? And this gentleman, first of all, appears to be fine if you watch the sequence of events, and he states affirmatively that he can complete these tests, and he does not do very well. I respectfully disagree with Attorney Meehan. As I watch the video of this case, he does seem like he's impaired to me. He's not quite all there. That, not just the emotional trauma he's dealing with respect to his family member, but I think he just doesn't seem like he's physically okay with respect to coordination, balance. His movements are slow, and the officer testified to these observations. Trial court found that the appellant's overall behavior was such, and the answer to questions he gave was such that the officer properly had probable cause to place him under arrest. I would ask the trial court or the appellate court to look at the body camera footage. I would respectfully assert that what I'm saying, I think you would find if you look at it. The gentleman was taken back to the patrol post and was given a breath test. He did test over the legal limit. His test result was .138. The Tucholsky case states that if the appellant enters a plea to an A1A charge, challenging the breath test is moot. I respectfully think that's a correct statement of law and should apply in this case. But we did put on the entire testimony of Matt Whitmer, who tested this machine. This is a very experienced test operator. He testified that when you have a low dry gas result and a low test result when you're testing your test solution, in his experience, that means likely there's an environmental contamination where your breath testing instrument's located. He then immediately looked around the room, walked into the bathroom that is directly adjacent to the breath testing room, and found that the toilet in the restroom had toilet bowl cleaner in it. He thoroughly cleaned the restroom, got rid of the toilet bowl cleaner. He took this test machine outside the room, ran the test again. With the test solution, it tested perfectly fine, which confirmed his suspicion. He brought the machine back into the patrol testing room and ran the diagnostic again. It tested perfectly fine. And based upon his experience, And the exactitude of his testimony, the trial court found that the state of Ohio substantially met the requirements of this test result, and it makes sense. This was not, the rule that Attorney Meehan cited applies if the test machine is not working correctly. This gentleman is knowledgeable enough to determine that this machine itself is working just fine. There was an outside contamination that caused a problem. He solved the problem, and the machine is and always has been testing correctly in this manner. On the whole, if the court looks at the body camera footage, and if the court agrees that an officer stopping behind a stopped car on a fairly heavily traveled road where the hazard lights are, does in fact justify a community caretaking intervention, I would respectfully argue that the trial court is completely correct. I think this will come down to how this court feels about police officers stopping behind a vehicle that has hazard lights on. It happens frequently. As a prosecuting attorney who's been around for a long while, it happens more frequently than people realize. But frankly, I think, given my experience, it's an important function for police officers to stop and take a look when there is the appearance of maybe something being wrong. And that's what happened in this case. Again, the first words out of the sergeant's mouth when she walked up to this pickup truck was, "Are you okay?" I think that's appropriate, but the state of Ohio will live with what you decide upon it. You'll have to look at the body camera footage and determine this. I do appreciate the consideration.
Thank you.
So I don't know that I've thought of it this way, and I know we've had a lot of different comments here today, parked versus stopped. I don't know that there's a difference. But to say that this vehicle is not lawfully parked would essentially be to suggest that it's always unlawful to stop at any point, even if it's just briefly on the side of the road. The officer in this case and what the state just presented was she had traveled past that area previously. The car wasn't there. She came back around, the car was there. So it's not as if this car is just parked there and is a sitting vehicle. Nobody called in about it. I think that makes a difference too. I don't think that we're suggesting that it's unlawful to briefly stop on the side of the road at any point, especially when you're parked in a manner that doesn't indicate that there's anything wrong. Some of the other things that I kind of take issue with what the state said is what this officer thought when she approached the car. So we're saying she's immediately coming in and flashing her flashlight in the back seat. Is that indicative of her purpose of being to check and see if everything's okay, or is she investigating something else?
He had seemed to indicate that in his view that was a typical police procedure to make sure the situation's safe and there's no other people there.
Sure.
Do you dispute that's something they do
I don't know
short of
that-
investigation?
I think that's something we more commonly see in criminal investigations. I don't know that she testified that that was the purpose of the hearing. But one of the things that the thing I take more issue with is the statement that she, at the moment, thought that she had enough to take him out of the car. Because what you'll see is before that even occurs, she goes back to her car, she makes a phone call to Officer Stepka or talks to him on the radio, and she starts talking about how bad she feels because of the circumstances that she's in, and she says, "This isn't physical control. I didn't see him driving." So her own perspective was she didn't have enough for what transpired, and it was when Officer Stepka said, "Oh no, you can get an OVI on this," and that's when she goes back. So I kind of take issue with what her subjective thought was at the time after she had the encounter before she even removes him from the car. As it relates to the breath test specifically, Mr. Whitmer did testify about the conduct that occurred where he removed the machine from the room that it was in and took it somewhere else. That's actually the current regulations that were enacted after this machine was certified. So he actually certified a machine in a way that wasn't under the current regulations that were in effect at the time of the certification, which is why my argument is that the machine in this case, until it was recertified in August, was not a properly certified machine.
Counsel, I'll know if your time is up for rebuttal if you would briefly conclude, please.
Thank you. And the only other thing I just wanted to note is, and that it happened in the hearing, so it's in the transcripts, there was there's no record of what Mr. Whitmer did with this remediation issue. He doesn't keep a record of it, it's not provided, but for
All
the
right, on
fact.
that, just briefly conclude, a conclusory statement, not more argument.
Oh,
Thank you.
okay, sorry, Your Honor. So our position here is that the stop was not valid to support everything that occurred thereafter, and essentially the motion to suppress should have been granted in that regard. The stop was impermissibly extended if this court finds that it was, in fact, a community caretaking function. The breath test should have also been deemed to be inadmissible at trial as well. So we would ask the court to reverse the trial court's decision denying the motion to suppress.
Thank you. The court will take the matter under advisement and issue a decision in due course. When the decision is made, it will be mailed to you by the clerk of court and also be available on the Ohio Supreme Court website. With that, I'd like to thank you on behalf of the court for your presentations today.